Okay, let's unpack this. Imagine a single violent moment, a physical fight, a hand grab, a desperate bite, and it just, well, spirals into this huge legal battle that basically shook up fundamental courtroom rights across New South Wales.
Yeah, it's pretty incredible. We're not talking about some massive complex fraud or, a murder trial here. It started with a bitten finger.
A bitten finger, and it ends with this really powerful, almost unheard of smackdown from the NSW Supreme Court. It became a serious cautionary tale for lawyers, didn't it?
Absolutely. The case is Bradley v. Senior Constable Chilby. And what's truly fascinating is how this seemingly straightforward local court matter just exploded. It became this landmark thing.
And not really about whether Bradley was guilty or innocent of the bite in the end, right?
Exactly. It pivoted to something much more fundamental. The absolute right of anyone accused of a crime to a fair trial. And that includes the prosecution's duty, their non-negotiable duty, to hand over all the relevant evidence.
You could feel the tension building. You had Bradley fighting for, well, his future, really. And then the prosecutor, Senior Constable Chilby, seemingly just digging her heels in, not wanting to share stuff that might actually help his case.
It was a real standoff. And the climax wasn't some dramatic jury verdict. It was this blistering judgment from the Supreme Court. Justice Adamson basically tore down the lower court's decision.
And forced the prosecution to completely rethink how they approached fairness. So for anyone listening, maybe you're in law, maybe you're studying to be a barrister, or maybe you're just interested in how the justice system is supposed to work. What does this all mean?
Well, that's our mission in this deep dive, isn't it?
Yeah.
We're going to cut through the legal jargon, using the court documents, the commentary, the notes you've got there.
Yeah, we'll take you step by step through this whole legal drama. We'll look at who the key players were, what the big legal arguments were about, follow all the twists and turns in the procedure.
And crucially, pull out those vital lessons, the ones learned the hard way in this case. Think of it as your shortcut to understanding why this case really matters for the integrity of justice.
Okay, so before we get into the timeline, we need to meet the cast, right? The people whose choices really drove this whole thing forward.
Definitely. These aren't just names on court papers. They're the key players, the dramatis personae, as you said. Their decisions shaped everything.
Kicking us off, naturally, is Harley Bradley. He's the accused man in the original assault case, and later he becomes the appellant, the one pushing the case up to the Supreme Court.
Right. He was facing a serious charge, assault, occasioning actual bodily harm. And his defense, from the get-go, self-defense.
And what really stands out about him is his persistence, isn't it? He didn't just, give up when things got tough in the local court. He kept fighting for what he saw as a fair go.
Absolutely. Then there's Senior Constable Deborah Chilby. Now, she wore two hats here, which is important. She was the police officer who investigated the alleged assault, and she was the police prosecutor handling the case in the local court.
So investigator and prosecutor, that's interesting.
It can happen in certain types of cases in the local court. And later, she became the defendant or the respondent when Bradley appealed. But the forces suggest she was pretty confident in her case against him.
But crucially, she was also the one resisting those requests for evidence from the defense. And that resistance, well, that's what ultimately put her actions under the judicial microscope.
Exactly. Then we have Magistrate Roger Clisdell. He was the magistrate in the Wollongong local court who heard that first crucial argument about disclosure.
His role was pivotal, wasn't it? He made the ruling against Bradley and used that specific phrase.
A classic fishing expedition. Yes, that line became infamous. His reasoning and that phrase were later picked apart and flatly rejected by the Supreme Court, really setting the stage for the appeal.
Okay, who was steering Bradley's ship legally?
That was Tim McKenzie, a solicitor from Legal Aid NSW. He took on Bradley's case right from the start. The sources paint him as really methodical, incredibly persistent.
Not just waiting for the police brief to land on his desk.
No, definitely proactive. He was digging for more information, writing letters, making formal requests, and ultimately he was the one driving the legal challenge that ended up in the Supreme Court. His behind-the-scenes work was the engine here.
And who argued that initial motion in front of Magistrate Clisdell?
That was Felicity Graham, a defense barrister from Black Chambers, instructed by McKenzie. She was the one presenting the detailed legal arguments in the local court, explaining exactly why the defense needed that specific evidence for a fair trial.
And interestingly, she later co-wrote an ethics paper about this very case.
Yeah, turning this whole courtroom battle into like a teaching moment for other lawyers shows the impact it had.
Right. So when it went up to the Supreme Court, who took over for Bradley?
That was Madeleine Avenell. a public defender, legal aid, and Tim McKenzie briefed her. She became Bradley's voice in the higher court. The source material describes her style as calm but forceful advocacy.
A style that clearly worked with the Supreme Court judge.
Seems so, arguing those fundamental principles of fairness and disclosure.
Okay, and who was on the other side in the Supreme Court representing Senior Constable Chilby and, effectively, the NSW police?
That was Ms. Kay Curry. She was counsel for the prosecution on appeal, tasked with defending the local court's decision and the police approach.
Which, as some commentary later put it, was like defending the indefensible. A tough gig.
A very tough gig, given how the law on disclosure was pretty clear and how things unfolded.
Were there other police involved?
Yes, we see glimpses of Chilby's colleagues. Senior Sergeant John Ryan, the head of police prosecutions in Wollongong, he received that formal, strategic letter from Tim McKenzie demanding disclosure.
Right, the one with the internal memo attached.
That's the one. And Sergeant Mark Casey, another police prosecutor, assisted Chilby during the local court hearing. He was involved in that rather unsuccessful last-minute attempt to review files in court, which Justice Adamson later criticized.
And finally, the judge who made the call in the Supreme Court.
Justice Christine Adamson. Her sharp legal mind and, frankly, her powerful and pretty blunt written judgment really cemented this case's importance. She used words like cavalier and legally unreasonable. Strong stuff.
Wow, quite the cast. It's amazing how their interactions, their decisions, some strategic, some maybe questionable, turned a local assault charge into this huge Supreme Court fight about fairness itself.
Absolutely. It's a stark reminder, isn't it? Everyone in the system, from the officer investigating to the magistrate to the judge, their choices matter hugely. Okay, so how did it all start? Let's go back before the storm.
Right. Late April 2018, Wollongong. Harley Bradley is at someone's house, a mutual acquaintance, with another person, Katie O'Connor.
And things get heated. There's a physical altercation. Now, according to Katie O'Connor's version later, during this fight, Harley Bradley bit her finger. Badly. Like down to the bone.
Ouch. That sounds serious. Hospital serious.
Yep, she needed hospital treatment. But, and this is key, there were two very different stories about how it happened.
Of course. Bradley's version.
Bradley claimed O'Connor had him in a headlock. He said he couldn't breathe, thought he might pass out, and bit her finger purely in self-defense, just desperately trying to get free.
And he also mentioned her state at the time.
Yes, he maintained she was heavily intoxicated, maybe affected by drugs, during the incident. So right from the start, you have these clashing narratives. The source material says the truth of that night would be fiercely contested.
Oh, wait, but if it was that serious, why wasn't it reported immediately?
Good question. There was actually a significant delay. About 6 weeks passed before Katie O'Connor formally reported it to the police.
6 weeks? Why the... Wait.
Apparently, she decided to report it based on advice from a community caseworker. So on June 8th, 2018, she went to the police and gave a detailed statement about her side of the story.
And this is where Senior Constable Chilby steps in.
Exactly. She becomes the investigating officer. Then, about a week later, June 17th, she arrests Harley Bradley. The charge: assault occasioning actual bodily harm under Section 59 of the Crimes Act.
Standard procedure after arrest.
Yes, he was taken to Lake Illawarra Police Station for an ERSFP. That's the electronically recorded interview of a suspected person.
The formal interview, all recorded.
Right. Senior Constable Chilby conducted the interview. And Bradley, well, he made some key admissions. He did admit biting O'Connor's finger. But, and this is the crucial bit for his defense, he immediately qualified it.
Yeah.
He told Chilby he only did it because he was in that headlock, couldn't breathe, it was self-defense, pure self-preservation, given O'Connor's alleged aggression and state.
So even in admitting the bite, he's laying the groundwork for his defense right there in the police station.
Precisely. As the source notes, those admissions foreshadowed the whole self-defense argument.
What happened after the interview? Was he charged then?
No, Chilby actually released him without charge at that point, pending further investigation. We learned a senior officer advised her to get photos of O'Connor's finger injury as corroboration.
So tying up loose ends?
Yeah, collecting photos, statements. Took a few more months until early September 2018. By then, Chilby felt she had enough to charge Bradley and take it to court.
Okay, so that brings us to entering the legal arena, the charge and the plea. September 3rd, 2018, Bradley gets his court attendance notice.
Yep. The formal start of the court case. The charge, as expected, assault occasioning actual bodily harm. And importantly, it's classified as a Table 2 offense in NSW.
What does Table 2 mean practically?
It means the case would normally be dealt with summarily In the local court think judge alone trial, no jury, unless the Director of Public Prosecutions, the DPP, decided to elect to take it higher to the district court.
And did the DPP elect?
No, they didn't. So it stayed in the local court system, which meant it would be prosecuted by a police prosecutor like Senior Constable Chilby.
Right. So first court date?
October 17, 2018, Wollongong Local Court. Probably just a brief mention initially. But the absolutely critical thing that happened that day was Bradley entering his plea, not guilty.
And that not guilty plea flicks the switch, doesn't it? It triggers the whole process for a defended hearing, a trial.
Exactly. And crucially, it triggers the prosecution's duty of brief service. They now have to prepare and serve their evidence brief on the defense.
And this is where Bradley gets his lawyer, Tim McKenzie, from Legal Aid.
Correct. And McKenzie, remember, he's described as proactive. He's not just sitting back waiting for the brief. He's already thinking defense strategy.
And in a self-defense case, the alleged victim's credibility is massive.
Huge. Based on what Bradley told him, and maybe some initial info, McKenzie started to suspect Katie O'Connor might have, let's say, a relevant history. Maybe past convictions for violence or dishonesty, maybe even current pending charges.
Why is that so important for the defense?
Because if a key witness has a history of, say, dishonesty, or if they have pending charges where they might want to, curry favor with the police, that can seriously undermine their credibility. It's vital ammunition for cross-examination.
You need the proof, though, right? You can't just hint at it.
Precisely. Just knowing someone has a history isn't enough in court.
Yeah.
You need the official records, the fact sheets, the details to challenge them effectively.
Yeah.
McKenzie knew this. So late 2018, he starts writing to Chilby, asking for more info. He even issues a subpoena to the Commissioner of Police.
A subpoena being that formal court order to produce documents.
Right. Trying to get things like O'Connor's official criminal history. Now, some stuff did come through via the subpoena process, and the standard police brief would have included O'Connor's statement, Chilby's own statement, the police fact sheet summary, the ERSP transcript eventually.
Well, McKenzie felt something was missing.
Yeah, he suspected there was more relevant material tucked away in police files, internal notes, other records stuff that could potentially help Bradley's case, and, under the law, should be disclosed.
Which brings us squarely to the core legal fight. The duty of disclosure, a battle behind the scenes. This is fundamental, isn't it?
Absolutely critical for a fair trial. In NSW, when someone pleads not guilty, the prosecution's duty goes way beyond just handing over the evidence they plan to use against the accused.
It's broader than that.
Much broader. It's based on laws like the Criminal Procedure Act, but also deep common law principles from higher courts. They have to disclose all material they have, or could reasonably get, that might be relevant. That includes stuff that could hurt their own case or help the defense.
Like undermining a witness's credibility.
Exactly. Even if it doesn't prove innocence directly, if it casts doubt on a key witness, it has to be disclosed. Basically, the prosecution can't play hide and seek with evidence. No ambushes.
But in the hustle of the local court, with police prosecutors handling lots of cases, maybe sometimes this broad duty gets overlooked.
That's certainly the potential issue highlighted here. Workload, maybe lack of specialist training compared to DPP lawyers. Whatever the reason, McKenzie wasn't having it. He ramped things up early 2019. April 4th, he sends this very formal, detailed letter.
Not just to Chilby.
No, crucially, also to Senior Sergeant John Ryan, the head of police prosecutions in the Wollongong. This wasn't a friendly chat. It was a formal legal demand.
And he backed it up with the law.
Yep. Cited specific sections, S-183 of the Criminal Procedure Act on brief requirements, S-15A1 of the DPP Act, about the police duty to give prosecutors all relevant info, including stuff helpful to the accused. He was spelling it out. Here's the law. You're not meeting it.
And then he pulled out the ACE card, the smoking gun.
Ah, yes. He attached an internal NSW police prosecutor's memo from 2014, written by his superintendent Ian Dixon. And this memo explicitly told police prosecutors they had to take a broad view of relevance for disclosure.
So he's using their own internal instructions against them. Genius.
Pretty sharp, wasn't it? He quoted bits from the memo in his letter, stuff like, prosecutors must not suppress evidence, must provide material that may cast a significant light on the credibility or reliability of witnesses, or anything that could reasonably be seen as capable of assisting the defense case.
Basically saying, your own bosses agree with me.
Exactly. And building on that legal foundation, his letter laid out this comprehensive wish list of exactly what the defense wanted.
What was on the list?
Okay, it was detailed. O'Connor's full criminal history, Any police fact sheets about her past or pending charges. Those are summaries of allegations, details of any pending charges she had, any other police records or intelligence about her credibility, CPS database entries for this specific assault charge.
COPS being the police internal computer system.
Right. Also, records of specific conversations Chilby had with other officers on key dates, Bradley's custody management record from his arrest day, and that important catch-all. Any other material which could reasonably be seen as capable of assisting the defense case.
Wow, that covers a lot of ground. He wasn't messing around.
No, he was demanding everything potentially relevant. And Chilby's response, dated April 11th, 2019.
Let me guess. Not cooperative.
Not really. She made very limited concessions, agreed to provide the criminal history and the COPS entries for the charge stuff that was probably coming via the subpoena anyway.
But the rest,
Yeah.
the internal chats, the old fact sheets, pending charges, details.
Flat refusal. She also claimed, incorrectly it turned out later, that custody record didn't exist. Her stance was essentially, I'll give you the absolute bare minimum I think you need, and that's it.
I decide what's relevant, not you.
Pretty much. And for McKenzie and Bradley's team, that just wasn't acceptable. They felt they couldn't properly challenge O'Connor's credibility or understand the police handling of the case without that information. They were being denied the tools for a fair fight.
So the battle lines were drawn. What was the next step?
Escalation. McKenzie instructed barrister Felicity Graham to draft a formal notice of motion. This was filed in the Wollongong local court on April 15, 2019.
So moving from letters to a formal court application asking a magistrate to order disclosure.
Exactly. And they included a really significant request in that motion. A temporary stay of proceedings.
Asking the court to pause the whole case, that's a big deal.
It is. It signals the defense thinks the lack of disclosure is so serious, so fundamental, that the case simply cannot proceed fairly until it's fixed.
So the stage was set for this courtroom showdown, not about the bite itself yet, but about the rules of the game, about fairness and access to information. Unusual for this level of dispute to reach a formal hearing, isn't it?
Very. Normally this stuff gets sorted out between the lawyers. The fact it went this far shows how entrenched both sides were. A real lesson for aspiring barristers there about choosing your battles and the risks of being inflexible.
Okay, let's get into that showdown in the local court. A classic fishing expedition. May 2019, Wollongong local court.
Yeah, imagine the scene. Local courts are usually buzzing, cases moving quickly. But this hearing, focused just on this pretrial motion, probably had an unusual intensity.
Felicity Graham is arguing for Bradley, instructed by McKenzie. What's her approach?
Methodical. She goes through each item requested, explaining why it's potentially relevant, why it's critical for a fair trial. She hands up McKenzie's affidavit with all the letters showing their efforts. She relies on her detailed written submissions, citing the case law, high court cases, R.V. Reardon stressing that broad disclosure duty.
Her core point being
that without these specific documents, the fact sheets, the pending charge details, they couldn't properly challenge O'Connor's credibility. They needed the actual material to cross-examine her effectively, not just fish around based on rumor. It wasn't about smearing her. It was about testing the reliability of the key witness in a self-defense case. She argued Bradley simply couldn't get a fair go without it.
And the prosecution's response, Sergeant Mark Casey arguing, with Chilby present.
Their line was consistent. The defense is asking for the moon. It's too broad, is burdensome for police. We've already given what's legally required for a fair trial. The rest, it's just a fishing expedition.
Trying to dredge something up without real justification.
That was their argument. We've given what's necessary. You're just trying to make work and maybe find a lucky break.
And Magistrate Clisdell, how did he react?
He clearly bought the prosecution's argument. His ruling, delivered orally on May 28th, was described as skeptical, maybe even impatient, and then came that famous line.
What is sought here is what might be said to be the classic fishing expedition.
Bingo. He felt the defense was just trawling without showing a specific need for each item. He did acknowledge O'Connor had a fairly lengthy criminal history: violence, dishonesty, drugs, being on conditional liberty.
But he thought the general knowledge was enough.
Apparently. He seemed to think the defense could just raise her history during cross-examination. Just ask her on the stand was his reported phrase.
Yeah.
He dismissed the need for the actual documents, worrying they might be incorrect or unproven or unfairly detrimental to the witness.
Did Graham try to push back on that?
She did. Tried to interject, explaining they needed the documents to cross-examine properly. But Clisdell wasn't having it. He apparently latched onto that catch-all request for any other material as proof he was just a wide-searching fishing net.
And he framed it as the defense trying to cause trouble.
Yes. He characterized it as an attempt to frustrate the prosecution, putting police to additional work, taking up court time on an optimistic exercise. He seemed really concerned about the practicalities, the resources.
Hearing to that dramatic warning.
Yeah, that allowing these kinds of demands could bring the criminal justice system in New South Wales potentially to a grinding halt. His message was blunt. You're asking too much. This isn't how we do it. Request denied.
So, the final outcome in the local court.
Complete dismissal of Bradley's motion. No disclosure order. No stay. The trial was going ahead, with the defense only having the limited info they already possessed. A massive loss for Bradley locally. Chilby won that round.
Wow. So Bradley's facing trial, potentially prison, feeling like he hasn't got all the info. What did they do?
Huge crossroads. Accept it and fight the trial handicapped, or appeal. They believe the magistrate had fundamentally misunderstood the law on disclosure and fairness. They decided to fight on.
They decided to appeal.
Yes. And that decision is what turned this from a standard local case into something much bigger. They sought leave permission from the Supreme Court to appeal Magistrate Clisdell's ruling, arguing he'd made errors of law.
Appealing a decision made before the final trial verdict, an interlocutory appeal.
Exactly, under the Crimes Appeal and Review Act. They weren't just disagreeing with his opinion. They were saying his legal reasoning was flawed. This ordinary case was about to go on an extraordinary journey.
Okay, so after the local court ruling, regrouping and escalation, the defense team regroups after that stinging loss.
Yeah, Tim McKenzie leading the charge. Their conviction is solid. The magistrate got the law wrong on disclosure scope, and he wrongly prioritized police resources over a fair trial.
So McKenzie files the appeal paperwork.
Promptly. November 7, 2019. He files the summons in the Supreme Court, formally starting the appeal process and asking for leave to appeal.
And the legal teams beef up for the higher court?
Definitely. This is bigger now. Legal aid briefs Madeleine Avenell, the public defender, to argue the appeal. McKenzie stays on as the instructing solicitor with all that background knowledge.
And on the other side, representing Chilby NSW police.
They bring in their own counsel, Ms. Kay Curry, instructed by the Crown solicitor or police lawyers. This is now senior advocates clashing in the Supreme Court, the individual versus the institution.
What were the specific legal arguments, the grounds of appeal?
Three main ones, basically refining Felicity Graham's arguments from below into claims of legal error by the magistrate.
Right.
Ground one, error in defining the duty of disclosure. They argued Clisdell used too narrow a definition of relevance, ignoring the established broad view required by cases like R.V. Reardon.
Okay, ground two.
Ground two, error in the purpose or abuse of process finding. They argued the magistrate was wrong to say their request was just trying to frustrate the prosecution or cause delay. They insisted there was zero evidence of bad faith. They genuinely needed the material for a fair defense.
And ground three.
Ground three, error in considering resource implications. This was key. They argued the magistrate wrongly factored in the alleged burden on police. Concerns about efficiency, they argued, simply cannot override the fundamental right to the information needed for a fair trial. That's just irrelevant legally.
So they had their arguments lined up. But first, they needed that leave from the Supreme Court.
Right. They had to convince the judge these were pure questions of law, not just disagreements about facts, and that it was in the interests of justice for the Supreme Court to step in before the trial. They'd argue these errors about disclosure were so fundamental they could set a dangerous precedent if left uncorrected.
Which brings us to the big show. The Supreme Court hearing, David versus Goliath in King Street, February 24th, 2020. Before Justice Christine Adamson.
Yeah, different atmosphere entirely. The grandeur of the Supreme Court building in Sydney, the formality, the awareness that this decision could have wide-ranging impact.
Madeleine Avenell arguing for Bradley. How did she approach it?
Calmly, forcefully, methodically. She hammers the case law, R.V. Reardon, No. 2, and others, showing how Magistrate Clisdell's reasoning, especially the idea that a fair trial was possible without the material, was just legally wrong. It contradicted what higher courts had consistently said about the broad duty.
Did she go through the specific documents requested?
Yes, reportedly walked Justice Adamson through each category, explaining its specific potential relevance. Why internal police conversations could matter, maybe showing doubt or instructions. Why pending charges could matter, motive for the witness, arguing none of it was frivolous. It all had a legitimate forensic purpose tied to the self-defense claim.
And Mr. Curry, for the police, defending the magistrate's decision.
A tough task, as we said. Her arguments echoed the local court stance. Disclosure isn't limitless. A fair hearing was possible without these extras. The requests were unnecessary fishing. The magistrate was entitled to consider efficiency.
How did Justice Adamson react to that?
With pointed questions, it seems. The source mentions her asking Miss Curry something like, "Are you suggesting that as long as some kind of hearing can happen without the material, there's no duty to disclose it?"
Challenging the core premise.
Exactly. It signals the judge sees the flaw who decides what's necessary for fairness, the prosecution. That argument apparently lacked legal backing and didn't sit well. The judge seemed focused on the paramountcy of fairness over efficiency.
And the prosecution didn't budge. No concessions.
Reportedly, no. An all-or-nothing stance. Miss Curry was apparently instructed not to concede anything, even when facing judicial skepticism. Probably didn't help their cause.
So after the arguments,
Justice Adamson reserved her decision. But the signs, as the source puts it, were ominous for the prosecution.
and Judgment Day wasn't far off.
Just 3 days later, February 27, 2020, Justice Adamson delivers her judgment in Bradley v. Senior Constable Chilby.
The outcome.
A decisive victory for Bradley, and, as the source calls it, a scathing rebuke of the prosecution and the magistrate. This judgment immediately became required reading in NSW legal circles.
What were the specific orders?
Okay, first she granted leave to appeal on grounds 1 and 2, disclosure scope and improper purpose, confirmed they were valid legal issues. Second, she allowed the appeal agreeing the magistrate made legal errors. Third, she set aside Magistrate Clisdell's entire decision, wiped it out.
And replaced it with what?
This is crucial. She ordered the local court case against Bradley be stopped until the prosecution fully complied with its disclosure duty. That's the hammer.
And she ordered a different magistrate hear it when it resumed.
Yes. A clear signal about Magistrate Clisdell's handling of the disclosure issue. A judicial vote of no confidence, essentially.
Any financial consequences?
Yes. She ordered the defendant, Senior Constable Chilby NSW Police, to pay Bradley's legal costs for the Supreme Court fight, a tangible penalty for resisting disclosure and forcing the appeal.
What about the judge's reasoning, the language used?
Powerful stuff. She firmly backed the broad view of disclosure. She even endorsed that internal police memo McKenzie used, saying it accurately summarizes the authorities. She stressed prosecutors need a generous view of relevance. If it might help the accused, disclose it.
What about the fair hearing without it argument?
Demolished it, found it legally unreasonable, and based on an erroneous premise fed by the prosecutor. She stated bluntly that idea had no support in the authorities, that the prosecution doesn't get to decide what the defense doesn't need. Full stop.
And the concerns about police resources.
Dismissed as misplaced. She pointed out there was zero actual evidence presented below, showing it would be difficult to find the documents. The too busy argument just didn't hold water legally or factually on the evidence presented.
Did she mention the Jones v. Dunkel inference?
Yes, subtly. She noted Chilby and another officer weren't called in the local court to explain the alleged difficulty, the inference. Their evidence probably wouldn't have helped the prosecution's "it's too hard" claim, another nail in that coffin.
And her comments on the prosecutor's conduct.
Very direct. The conduct of the prosecutor in the present case falls far short of the duty required of her. And she used that stunning word, cavalier, to describe Chilby's approach. Careless disregard for a fundamental duty.
She also commented on the appeal arguments.
Yes, expressed astonishment, really, that Mrs. Curry was instructed to defend the magistrate's approach, even though it was, in Justice Adamson's view, clearly non-compliant with the law. She saw it as the police institution stubbornly defending the indefensible, a real smackdown.
Did she mention that attempt to check files during the local court hearing?
She did. Criticizing it as inadequate, getting an officer unfamiliar with the case to do a quick scan wasn't proper disclosure. Highlighted the irony. The police's own internal memo got the law right, but the prosecutor on the ground didn't follow it.
So summing up the judgment's effect.
Appeal allowed on the key grounds. Disclosure duty is broad. Resource concerns are irrelevant to the right to disclosure. Orders. Stay the case until full disclosure. Get a new magistrate. Police pay Bradley's costs. A comprehensive win for the defense on the procedural fairness front.
Imagine the relief for Harley Bradley. He hasn't won the assault case itself, but he's won the right to fight it fairly.
Exactly. He gets a level playing field, all relevant evidence, and a different decision maker for the prosecution. Huge delays, and now they have to do the disclosure work they resisted. It showed an ordinary person can force the system to uphold their rights.
And the ripples from this judgment spread wide, didn't they? Beyond just Bradley's case.
Oh, massively. Bradley v. Chilby became this instant cautionary tale and a powerful precedent throughout the NSW legal world.
How was it received? Press? Legal commentary?
Covered widely. Law Society journals, legal blogs like Sydney Criminal Lawyers, even news sites picked it up, often with a sense of surprise like, wow, did the Supreme Court really need to spell out these basic fairness rules again so forcefully?
And the key message hammered home.
That the duty of disclosure is serious, it's broad, and it applies just as much to a police prosecutor in the local court as it does to a senior Crown prosecutor from the DPP. Justice Adamson made that crystal clear. No shortcuts allowed.
So a massive warning for all prosecutors.
Absolutely. Don't hold back relevant evidence. Don't decide for the defense what they do or don't need. Your job is fairness and justice, not just winning. Chilby's cavalier approach, as the judge called it, led to her case being stalled, judicial criticism, costs orders, a hard lesson learned.
But on the flip side, an inspiring story for defense lawyers.
Totally. Think about it. McKenzie, Graham, Avenell. They could have just accepted the local court loss. It happens. But they didn't. They saw a fundamental principle at stake, the right to proper disclosure for a fair trial, and they fought for it.
Using all the legal tools.
The letters citing the law, the motion, the stay request, the appeal citing specific errors. It shows tenacity pays off. And even seemingly small cases can raise huge justice issues that are worth fighting for.
It really highlights that link between legal ethics and good strategy, doesn't it? Especially for young barristers.
Definitely. Understanding your ethical duties, like disclosure, isn't just about ticking boxes. It is good strategy. Ignoring it, like the prosecution did here initially, blows up in your face. Building your case on ethical foundations, like the defense did fighting for fairness, gets results.
And commendably, the defense team turned this into a teaching moment.
Yeah, McKenzie, Graham, and Avenell actually wrote an ethics paper together afterwards. When you don't know what you don't know, 10 things you should know. Shared it late 2020.
Aimed at who?
Police prosecutors, less experienced lawyers mainly. Distilling the practical lessons from Bradley v. Chilby. Fantastic example of lawyers using a win not just for the client, but to improve the system.
So the big question remains. What actually happened to Harley Bradley's original assault charge in the end? Did he go to trial?
The public records don't make it obvious. We know the case went back to Wollongong local court, stayed until disclosure happened, and needed a new magistrate.
So after all that delay, full disclosure finally happening, new magistrate. What's likely?
Well, you'd have to think the prosecution would have seriously reevaluated. The defense now had all the material they needed to potentially challenge O'Connor's credibility effectively. It's plausible, as the source suggests, the case might have been withdrawn or maybe settled some other way.
Or maybe it did go to trial, but a much fairer one for Bradley.
Exactly. Whatever the final verdict on the charge itself, the Supreme Court appeal guaranteed the process leading up to it was fair. That was the victory here.
It's more than just a dry legal case, then. It's about people, decisions, consequences.
Absolutely. The initial bite, Chilby's stance on disclosure, Clisdell's ruling, the defense lawyer's persistence, every choice mattered. Justice isn't just automatic. It has to be actively pursued and defended.
So the takeaway for prosecutors and police is pretty stark.
Know your duty of disclosure. Understand how broad it is. Do it properly. The courts will protect fair trial rights, and ignoring them has serious consequences for the case, for you professionally, for public trust.
And for defense lawyers, especially those starting out.
Be vigilant. Hold the state accountable. Don't be afraid to fight procedural battles when fundamental fairness is at stake. That is the real work sometimes. It protects not just your client, but the integrity of the whole system.
Justice Adamson's judgment really sent that message loud and clear across NSW, didn't it? Fairness isn't optional.
It's fundamental. It's a right. And Bradley's long journey, from that bite to the Supreme Court, really underscores that the fight for justice is ongoing. It relies on lawyers having the knowledge and, frankly, the courage to stand up when legal principles aren't being followed.
So for every aspiring lawyer listening, and really for anyone who cares about a fair go in our justice system, the lesson from Bradley v. Chilby is profound. Sometimes the crucial battles are fought over procedure, not just the final facts. Sometimes it's an uphill climb. But when those core principles of fairness are threatened, fighting for them is not just worthwhile, it's essential. Because upholding those principles in one case helps safeguard the integrity of the entire system for absolutely everyone.